So I'm Eric Jones. I am the Weber River Western Regional Engineer with the Division of Water Rights, as introduced. And for those of you that have been grumbling about having to flip back and forth through the booklet and find the right page, it's because of me. I agreed to the 8:30 slot, not remembering that I'd have to drive carpool Thursday morning. So I apologize for that, but I also apologize for the increased potential of paper cuts as you flip back and forth through the book. Okay, so just when you guys thought, hey, these topics we're talking about are real basic and real boring, but now we're going to talk about advanced topics. And a lot of these topics, if you don't do them on a regular basis, are difficult to understand, and for me, probably a little bit difficult to describe because I have pretty poor communication skills as an engineer. So we got a nice recipe for disaster coming up here right now, okay? But anyway, come with me. We're going to talk about these three main points. We're going to talk about forfeiture, which there's a lot of forfeiture talk in the last question session, which is good. Give you a little sample. Non-use, in particular non-use applications, and then the best topic you're ever going to learn about in your life, the rebuttable presumption of quantity impairment due to non-use. Throughout my presentation, I have built in a few breaks for questions. Really, they're breaks for me to get a drink of water. So if you just want to get your questions ready, and then when I do a question break, we can kind of throw them out there. But feel free to throw questions in the chat, and I'll address them during the question breaks. And I also ask that the questions be about the general ideas that we're discussing and not specific to your project that you have. If you have specific questions, you can contact us directly, or like Teresa offered yesterday, you can contact her directly. That would be great. Okay, forfeiture. Forfeiture is a fundamental concept of the prior appropriation doctrine here in the state of Utah. And we find the definition of forfeiture in section 73.1.4 of Utah Code. The street slang for forfeiture is use it or lose it, right? So I'm sure you've heard that phrase before. A water right is pretty similar to a muscle. If you only have to work the muscles you want to keep. So if you want to keep a water right, you have to work it, you have to use it. So a water right is subject to forfeiture if it hasn't been used for a period of 7 consecutive years. So you can use it for 1 year, not for 6, and then use it again, and that water right wouldn't be subject to forfeiture, but you'd have to have evidence showing that that's how it had been used. Let's see. Sorry, I apologize. So if we move on here, a forfeiture action is a judicial action. The state engineer does not declare a water right forfeited. The state engineer does administrative actions. So I want to reiterate that. The state engineer does not take away a person's water right. We can make a recommendation to a judge that a water right be disallowed, and then the judge can make a decree that that water right is forfeited at that time. So, holy cow, I really should get into this technology thing. It'd be a lot easier, I think. Ultimately, it's a judge that makes that decision that a water right is forfeited. Now, if a water right is not used for 7 years and then someone decides to put it back to use and they use it for 15 years, that water right is no longer subject to forfeiture. You can't file a forfeiture action against a water right that has been placed back to use for a 15-year period. Let's see, so what happens when a water right is forfeited? It reverts back to the public. So the water associated with that water right now becomes public domain. And if the forfeited water right is in an area that was closed to new appropriations, then the water right, or the water, just gets used in priority. So now the junior water rights maybe get more of their water right fulfilled every year because that water right has been forfeited. If it's forfeited in an area where it's open to new appropriations, then that water is now available to be appropriated, and someone can file an application to appropriate on that volume of water that has been forfeited. If you are looking for water rights that have been forfeited on our database, you would look at the status line, and it would say terminated or disallowed. And that's kind of just for your information, and you can take that for what it is, and you can use it to your benefit. So, who files a lawsuit to create this forfeiture action? Well, primarily it's an aggrieved party. So imagine if there's a spring and the spring serves 2 water users, and water right holder A says, hey, under their own volition, they say, I don't want to use this water right this year or next year or for 7 years. But in the 8th year, they come back and they say, okay, I'm going to start using it again, to the detriment of the other water right holder on that spring. So the water right holder B would be the aggrieved party, and they could file a forfeiture action against water right holder A. But if they don't do it for 15 years after water right holder A has put his water right back to use, then that water right is no longer subject to forfeiture, and they can file the forfeiture action, but a competent judge would dismiss the case saying, well, here's the timelines. The water has been used for 15 years. It's no longer subject to forfeiture. The other party that can take a forfeiture action would be the state engineer, and it's generally performed through an adjudication. So the state engineer would make a recommendation to the court saying this water right is not being used, therefore we recommend it be disallowed. And disallowing a water right is similar to forfeiture, but again, ultimately it's the judge that comes in and says, okay, let's look at this disallowed water right, and then the judge decrees it is forfeited through their determination. Okay, so that's question break number 1. And okay, I see that question I can't see all of that question. Isn't this a way to steal water rights from users? Does the state compensate the holder? When the water right is resold, I can't see the last part of that line, but I can start with the first 2 questions. It is not a way for us to steal water rights from users. So the primary objective of our office is to make sure that water is being used in most efficient way possible. So forfeiture actions are typically taken by people outside the state engineer's office, not by us. And that's because their water right is now being harmed or injured through someone bringing their water right back to use. So they would take a forfeiture action. And the state does not compensate the holder. So I'm not 100% sure if that's through monetary means or not, but the state does not provide any monetary compensation for a water right that has been forfeited. Again, it's that idea that if you want to keep something, you have to keep using it to the best of your ability. When the water right is resold, who receives the funds? That again, water rights are real property, so the holder of the water right, when they sell it, would receive the funds. But if I'm understanding that question correctly, you're talking about a forfeited water right. So you can't really resell a forfeited water right. In the case that a new appropriation we filed, that would just be a new appropriation, and that person would have the real property. Okay, the next question from Tyler Stewart says, when a water right is forfeited and someone applies for said forfeited water, which priority date is given with that new application? It would be given the whatever filing date of that application. That'd be the priority. So the new water right would be very junior in the system. The original forfeited priority, oh yeah, there you go. Okay, that was just a second question clarifying the first question. So I think I answered that question. Let me grab a drink. Okay, so there are exceptions to non-use, and here are the exceptions. Okay, we have approved non-use applications. If you have a lease, now the lease must be written and agreed upon. If you're participating in a government fouling program, that's an excuse for non-use or an exception to non-use. If there's insufficient water in your source, so let's say you have a junior water right and you're the last one on the stream and the stream cuts out every year except for 1 out of 10, and you use it that 1 out of 10, and you can show that to us, then you're excused from non-use. One of the other ideas is priority cuts. So if you're on a system like, for instance, the Weber River where I operate, often the water rights get cut up into 1865 priority. So if the water right isn't used to its full extent, and it's because of priority cuts, that can be demonstrated to our office, and that portion of the water right is not subject to forfeiture. If you participate, let's see, did I go back? No, there we go. Okay. If your water right is in a water storage, surface or groundwater recharge project, that's excused. If you are using substantially all of the water that you're allowed to use, that's excused. If you're a public water supplier, now here's one of the magic dates in statute, May 5th, 2008. If you're a public water supplier and you acquired the water right prior to that magic date, you're excused from non-use and forfeiture action on that water right. If the water rights are supplemental, then the water rights are also excused from non-use as long as you're trying to use the water rights to the best of your ability. If you have a change application that's approved and you're diligently pursuing that change application, your water right is excused from non-use. Again, just remember that if you are trying to use your water right, you're probably excused from non-use, and there's some way that our office can work with you to have you avoid forfeiture, or not us, but maybe your legal counsel. Okay, so that's question break number 2, and I see a question from Matthew Kennedy. It says, if flow is reduced to drought, what documentation might be required to prove that? So if you have a stream gauge on the stream that you use or a measuring device, and you can show that, hey, look, this is how much precipitation we received in that year, and the source didn't produce as much as we were used to, so therefore we couldn't use all of our water right. That's the data that we would need. We'd need to see just flow measurements and precipitation data to coincide with your claim that you used everything that was available to you. Okay, the next question comes from Logan City. Are your municipal water rights subject to forfeiture? Yes, they are. Next question is, for example, the city has a water right that has not been used for 10 plus years, but now wants to do a new point of diversion, a new well. Can that be done? Okay, so all water rights are subject to forfeiture. But again, if you're a public water supplier and you acquired that water right prior to May 5th, 2008, that's an excuse for non-use. You just say, hey, we're holding that for the benefit of the public for the future, and that's you're excused from non-use in that case. Or if you had a change application that's approved already, that's an excuse of non-use. And I believe that depending on when you acquired the water right with drilling a new well, that could be done pretty easily. Again, I think that's a specific example, and you'd probably have to contact Will Atkin or Skylar Buck in the Logan office and ask for specifics on a specific water right. But in general theory, yes, I believe you'd be okay to file a change on that water right. Okay, how would an aggrieved party prove non-use? So the aggrieved party would have to collect similar data to what I was talking about before, in that they'd have to show, hey, I know that this water right holder is supposed to irrigate this field with their water right, and they didn't irrigate it this year, and they didn't irrigate it the second year, so I think photographic evidence would be great. You can have written documentation where you're taking logs. So, and you're creating. We do have aerial imagery that's pretty regular now. So you might be able to collect some aerial imagery from every year that would show non-use is occurring. But those are the things that I would think of to prove non-use for a 7-year period. Okay, are there any more questions? Doesn't look like it. I really am. I can see like a little piece of me in this little screen, and I don't know, but I'm just staring right at it. Is there any way that we can get me moved? I'm like a bird, and I look at myself in the mirror, and I can't. I apologize for that.
He can't focus now.
Yeah, I'm all over the place. Okay, but that was the end of the question break, and we can move on. Okay, so now we're moving on to non-use applications. A non-use application is the easiest protection you can carry as a water right holder. What do non-use applications do? They allow a water right holder that knowingly does not want to use their water right to be protected from forfeiture. Non-use applications only protect a water right from the date of filing to the date of approval. So once the non-use application expires, that water right is no longer protected by said non-use application. A non-use application does not constitute beneficial use. This is an important aspect. So if you have a water right that you haven't used for 7 years and you file a non-use application and you do that for 15 years, that doesn't erase that's not that magic 15-year period. Okay, that water right is still subject to forfeiture 7 years prior to the filing of the non-use application. Non-use applications are good, but they're not the solve-all to your problems and issues. Moving on. So non-use applications, you can file a non-use application on all or part of a water right. A non-use application may be filed by the appropriator or the appropriator successor in interest. Again, let me reiterate that a non-use application is not beneficial use of a water right. And a shareholder, you just got done listening to the difference between a share statement and a water right. A shareholder can file a non-use application on their portion of stock that they own in a company, but they need to provide written notice to that company that they are planning on filing a non-use application. If you file a non-use application, does that prohibit you from using your water right in part or in full? And it does not. Yes, even though you have a non-use application, you are still allowed and still approved to use your water right to the best of your ability. So the state engineer, it says in code that the state engineer shall grant a non-use application, and so the state engineer more than likely will approve a non-use application that is filed with our office, as long as the cause for non-use is reasonable. What are reasonable causes, you ask? Here they are. Reasonable causes include financial hardship or economic depression. It could be physical causes that render use beyond reasonable control. If you participate in a water conservation or efficiency practice or groundwater recharge recovery program. If your water right is part of a legal proceeding and the court has said, hey, you can't use this, so you file a non-use and say, hey, I've been ordered by the court that I can't use my water right, that's a reasonable cause. If water is held by a public water supplier to meet the future requirements of the public, that's a cause for non-use. If there's a management plan in place and non-use of a water right will help with that management plan, then that's a reasonable cause. If the source that you're using has a loss of capacity due to deterioration of the supply equipment, then that's a cause for non-use, but that cause must include a plan on how you're going to restore your water supply equipment. There are many other reasonable causes for non-use, such as a zombie apocalypse. I know that we worked through pandemics this last year, and we've worked through tornadoes and earthquakes and governor's news conferences. So I imagine that during a zombie apocalypse, we will be ordered by the state legislature to keep working. So you could keep filing your non-use applications and say, zombie apocalypse is the reason why I'm not using my water right, and we would accept it. Okay, with that, we got question break number 3. Now I can't see the questions.
I don't see any on the chat. I think they do like the zombie apocalypse excuse, though. That's a good one. Anybody have any questions right now before we move forward? Okay, I think you're good.
Okay, yeah, and if you submit a non-use application and we read the cause and we think, well, that's not reasonable or it doesn't make sense, we will probably, prior to rejecting it, we will reach out to you and get more information to clarify why you want to put your water into non-use. We really do just want to approve those applications and help you protect your water right. Okay, now we're moving on to the most fun you're going to have today, probably tomorrow, and I'm guessing through the weekend, because we're talking quantity impairment. Quantity impairment is something the state engineer looks at for the approval of a change application. What the heck is it, and how contagious is quantity impairment? Basic quantity impairment is a reduction in the amount of water available for an existing water right. If a change application on a water right comes to town, or applies to move to a certain area and will diminish the quantity of water, changes the time of water, or enlarges the depletion of their existing water right, then the changed water right may quantitatively impair an existing water right, which is no bueno. Okay, so that's basic quantity impairment, and that's one of the first things we look at in the change application process is, will this water right, if it moves somewhere else, will it impair existing water rights? So there's another form of quantity impairment that we also look at, and we find both forms in the Utah Code 73.3.3 and 73.8. Did I say too many threes on the first one? I always feel like I say too many threes. My audience over here is giving me thumbs up. Okay, so the applicant in the change application process bears the burden to provide evidence that the change can be made that won't, one, do the basic quantity impairment, won't impair existing water rights. Okay, and they also have to provide evidence that, two, that the water has been used, and therefore they can overcome this B number right here, which is rebutting the presumption of quantity impairment. So if we get an application in our office, it's filed with us, we look at it and we say, okay, let's go and look at the historical place of use. And as we look at the historical place of use, we say, okay, can we see use at the historical place of use? And if we cannot see use at the historical place of use, then we can enter into this part B, okay? So let's have this nice graphic here that helps us understand, okay? So quantity impairment, it breaks into two categories, and it is always the applicant's burden to produce evidence to overcome quantity impairment. We have quantity impairment A, which is basic quantity impairment, which is, hey, you're going to move into an area where there's existing water rights. Are you going to impair those existing water rights? And then you have quantity impairment B, which is what we're really going to talk about, okay, in the next few slides. And the B quantity impairment is a senior water right being put back to use, impairing junior water rights. So quantity impairment A protects senior water rights from junior water rights, and quantity B protects junior water rights from senior water rights. It's confusing, but hopefully we can talk about it and get through this. Okay, and that brings us to our next question break. Okay, from Tyler Stewart, is a loss of carrier water considered an impairment? Let's see. That's a good question. So I guess it depends on what the cause for the loss of carrier water is. If it's just environmental impacts, then probably doesn't constitute impairment. If it is clear and obvious that the impairment is being caused by a change application that moved upstream of the senior water right, then yes, I think that is basic quantity impairment, and the senior water right holder can claim injury and interference with the court and claim impairment. Okay, are there any other questions about the two forms of quantity impairment and how we look at them from the state? Okay. All righty, we're moving on. Okay, so we're going to talk about the rebuttable presumption of quantity impairment. And rebuttable what now? I mean, it's a mouthful, and I'm about to say rebuttable presumption of quantity impairment about 100 times. So get ready. But what exactly is a rebut, and how much does a plastic surgeon charge? Do you think it's per cheek, Jim, or is it 2 for 1? What is it? Hey, got some laughter. All right. Okay, I'm getting the move on signal from Jim. So rebuttable presumption of quantity impairment is a mechanism used by the state engineer to consider non-use of a water right during the change application process. So again, I talked about when we receive change applications, we go and we look to see if we can find the historical place of use. And then we look and we use aerial imagery, which is the best available data we have, and we look back 7 years prior. And hopefully when we go and look at the current imagery, we say, okay, yeah, that's clearly been used. Either we see green irrigation, or we see stockyards, or we see houses, okay, or we see an industrial complex, something like that, where we say, okay, this water right's approved for irrigation, we see irrigation here. But if we don't see it in the current imagery, then we go back to the next year, and we go back to the next year, and we go back to if we go back 7+ years and we never see use at the historical place of use, then we have to trigger the rebuttable presumption of quantity impairment. And we say, hey, it doesn't look like your water right has been beneficially used at the approved place of use, and given that fact, we can assume that it hasn't been diverted from the approved point of diversion. So to avoid quantity impairment, you have to do both things. You have to divert and beneficially use the water as approved and as defined on your water right with the records of the state engineer. So if you were to bring this water right back into use through a change application, you may impair junior water rights that have come to rely upon the water that the senior water right wasn't using. Okay, so if you haven't been using your water right, then get ready to file documents rebutting the rebuttable presumption of quantity impairment. So who are the parties that can raise the rebuttable presumption of quantity impairment? We have one, the state engineer's office. The statute clearly identifies that they have 90 days from the day of filing to raise the rebuttable presumption of quantity impairment. The other people that can do it are protestants, as long as they do it in a timely manner during the protest period. Both parties, if they raise this rebuttable presumption of quantity impairment, they must identify a water right that is junior to the base water right of the change application that will experience quantity impairment if the senior water right was put back to use. This is just a whole bunch of loop talking, but if I keep saying it over and over again, I think it'll stick, and you'll go to sleep tonight, and you'll think, and you'll dream, and you'll be like, okay, yeah, that makes perfect sense now. Okay. So how do you rebut the rebuttable presumption of quantity impairment? Oh, hang on, I might have missed a question break. Nope. Okay, so if you are the applicant and rebuttable presumption of quantity impairment is raised, which means that the state engineer or the protestant claims that they could not find use within 7 years prior to the filing of the application, it is now your duty to file documentation that says, I have used it within the last 7 years, or you need to file documentation that excuses you from using the water right. Okay, and so there are excuses built into Utah code. Okay, and those excuses are outlined in 73.3.8. So we have exceptions to non-use, which we briefly went over before, and we're going to go over those again in a minute. If you have an approved non-use application, that can excuse you or can help you rebut the rebuttable presumption of quantity impairment. But again, if you had the 7-year period of non-use, then you filed your non-use application, you still need to provide documentation. I did a lot of work with some water rights in a certain area where that was their case. Like, we had confirmed from them that they stopped using their water right in 2000. In 2008, they filed non-use applications trying to protect their water right, but we still had to raise the rebuttable presumption of quantity impairment on that change application that was filed on those water rights and the segregated children. Okay, if your water right is subject or is in-stream flow, and we're going to kind of skim over that because that really only applies to a couple agencies here in the state of Utah, or if you have done the passage of time, so you're no longer subject to forfeiture. So if you had the non-use period for 7 years, put the water right back to use, and then you did it for 15 years and then filed the change application, then that water right is no longer subject to forfeiture, and you can give us that data and provide us that information, and that would rebut the rebuttable presumption of quantity impairment. Okay, so let's take a question from Eric Edgley. Can my own date-stamped photos of BU be used as proof to rebut a non-use claim? I think they can definitely be added to the pile. What is BU exactly? Before I go on answer, beneficial use. Is that an acronym we're using now? Is it beneficial use, Eric? Yes. Okay. Perfect. See, you should have just typed it the first time, and then we wouldn't have had this whole thing. But that's okay. Okay. Eric and I used to work together, so that's okay. I don't know if he's in the building. He might come down and hit me, which is fine too. It can be added to the evidence, but if your date stamp isn't like an electronic date stamp built into your camera, then I think we might have, like, if you're just backdating a rolling stamp and stamping the back of a photo, like this is the date I took it, I don't know if that really helps you out. But if it is built into the camera, then I think, yeah, that is good to collect and to keep as evidence to show beneficial use. Okay, are there any other questions about that before we move on?
Thanks, Eric. Good to see you again.
Yep, nice seeing you. Well, I can't see you, but yep.
I wonder who got the short end of that stick.
Not him. You see my sweet mustache I got going?
It is impressive.
Okay, so as promised, here are the exceptions to non-use. Again, so if your water right fits into any of these, lease, fallowing program, if you can prove there was insufficient water, if your water right was subject to priority cuts, if your water right is part of a water storage program, if you have been substantially using as much of your water right as you could, or if you're public water supplier, we're going to do a little more detail on that. Again, supplemental water rights, and if you have an approved change application, these are all exceptions to the non-use. And hopefully we have those records already, but if we don't, then you can submit those official documents, okay? So let's talk about a lease. So if you have a lease, usually a lease kind of is a verbal agreement between two parties. At least most of them that I've come in contact with are verbal agreements. And when the statute was originally passed, we were accepting verbal agreements. And you coming and telling us, oh, yeah, well, I'm not using it on my field. I've leased my water right to Bill over here, and he's using it on his field. And we've said, okay, that's fine, but you do know now that Bill has to retire that acreage if you want to file a change application on it. So now we've come back and we said a lease needs to be written documentation and preferably signed by both parties or all parties that are participating in that lease. And it also needs to be clear that the use can be terminated upon if the application is approved. I always got to remember to say ifs, okay? Because there's no guarantees in change application land. So the other specific thing that happens on a regular basis is that the water right is either now owned or the public water supplier received deeds but has an updated title with our office. And so they're claiming, hey, we're a public water supplier, we're excused from non-use. So again, we have that magical date, May 5th, 2008. If the water right was acquired prior to that, then that works. If not, then I think you got a little more work to do to provide us evidence showing the use as defined on your water right. Okay, so we're running short on time, and I've got a couple scenarios here. So normally this would be kind of a back and forth, but since Jim's the only one here, I'll just kind of read the question and then you guys think about the answer, and if you get it right, pat yourself on the back. If you get it wrong, you have another scenario to try. Okay, so Farmer Bob files a change application on a water right with an 1890 priority date. The historical place of use is now a Walmart parking lot and has been for 10 years. A protest has been submitted alleging quantity impairment due to non-use. Protestant's water right has a 1910 priority. Has the rebuttable presumption of quantity impairment been raised? If you said yes, you are correct. Okay, could they also raise basic quantity impairment? And again, the answer is yes. Basic quantity impairment could be an issue in this case. So rebuttable presumption of quantity impairment has been raised because the protestant's water right has a junior priority to the applicant's water right. Okay, so but if we change the dates and we say the applicant's water right is 1940, same scenario, has rebuttable presumption of quantity impairment been raised? And the answer is no, it has not been raised because the applicant's water right is junior to the protestant's water right. But basic quantity impairment may still be an issue, and the applicant still may need to provide evidence overcoming basic quantity impairment. Okay, next scenario. Okay, we have a change application is filed on a water right in 2021. An approved non-use application was filed in 2015. It is clear and obvious the water right has not been used for more than 7 years prior to 2015. Can someone, and someone includes the state engineer's office, raise rebuttable presumption of quantity impairment? And the answer is yes, because a non-use application does not constitute beneficial use. So if the non-use period is prior to the filing of a non-use application, the 7-year period of non-use prior to non-use application, then that water right is still subject to forfeiture, first of all, but it's also subject to this rebuttable presumption of quantity impairment. Okay, next scenario. Okay, this scenario is just things to consider. So let's say you have someone files a change application today on a water right pertinent to land that is owned by a big box store built in 1996. Okay, so things that you should consider with this change application is who actually owns the water right? Is it the water right holder or is it the big box store? Because water rights do transfer by appurtenance unless severed by a deed. So you need to check the deeds and check the title to make sure everything is in order before well, not before, you can do it after if you want to, but I'd recommend doing it before. The other thing you can do is verify to see if a non-use application has been filed. That's easily done by checking the records of the state engineer. You can quickly look at our database and the information will be down at the bottom, but it's better to look at the actual scanned documents, or once you guys feel comfortable coming back into our office, coming and getting the physical file and looking at the documents. And just be aware that, hey, the building was built in 1996, you're filing an application in 2021, clearly been 7 years since the building was built, so you may have to rebut the rebuttable presumption of quantity impairment. So what should you guys do? You should be proactive, okay? So don't ignore certain things like this, okay? The applicant always bears the burden to provide the evidence to our office. And again, verify to see if non-use is excused, because if it is excused, then there's your proof and evidence right there. And as always, you can always do a preemptive strike. You can make your case on the change application, either in the explanatory, like give us information like, hey, I know it's not been used at my approved place of use, but there's a lease, and here's the lease agreement signed by both parties. Or one of our favorite things to see on applications are heretofore maps, clearly delineating here's where my acreage is that I'm going to retire if this change application is approved. Okay, so with that confusing rigmarole, I am done. And last questions? I don't see anything, but that's probably because everyone already went on their break 2.5 minutes ago.
Anybody have anything? Oh, okay, let's see. I think that's it.
It did sound like pity laughter. I don't know this Jeff Mexican's character, but we'd be friends. I'm pretty sure we'd be friends.